I'm Alex Landon. I'm an attorney, and also I teach a bit as an adjunct professor at the University of San Diego School of Law. I teach corrections and sentencing law, and I'm also on the AXSOL board. And today we're going to talk about modifying conditions of probation, supervised release, and parole, which includes the possibility of termination. So let's jump into it. You want to give me the next one? All right. So basically, as to each of these things, probation, supervised release, and parole, different types of supervision, there's general conditions, and then there's special conditions. And the general conditions are considered to be mandatory terms that everybody gets, and the special conditions are discretionary terms. Not everybody has to get these. So again, the general conditions are hard to modify unless you're completely off. The special conditions, there's some possibility there. Okay, the next one. And then there's the different types. So probation, supervised release, not usually parole, can either be formal or informal. If it's formal, it means it's being supervised by a probation officer or perhaps parole agent. If it's informal, it's unsupervised and usually monitored by the court. If you're on probation or supervised release, then the court is the one that you are technically being monitored by, but it's informal, obviously not as stringent as formal probation, supervised release. Okay, next one. All right, talking about California probation, the code section that kind of guides this is California Penal Code section 1202.7. And it's important to at least know what it says. This is what the legislature has basically said about probation. It says the legislature finds and declares that the provisions of probation services is an essential element in the administration of criminal justice. The safety of the public, which shall be a primary goal, through enforcement of court-ordered conditions of probation. And then they look at the nature of the offense, the interests of justice, including punishment. And this next one is important: reintegration of the offender into the community and enforcement of conditions of probation, the loss to the victim, and the needs of the defendant. Again, I'd like to underline that the needs of the defendant shall be the primary considerations in granting probation. So those are the things that are looked at in granting probation, but I think that they're relevant in dealing with the supervision that happens after the individual is placed on probation. And so the idea here that the needs of the probationer is important and the reintegration of the individual into the community is important. That, as far as I'm concerned, ties directly to the types of conditions that an individual is going to be under. Next one. We had a change in California this year under Assembly Bill 1950, and it was effective January 1st, 2021, which gave us Penal Code section 1203 small a. And what this does in California is it limits the term of probation for misdemeanors to 1 year and for felonies 2 years. So prior to this time, you had situations where people were being placed on misdemeanor probation for 3 years, felony probation 3 to 5 years or more. These are limits now. The one exception, again, is if there's a statute, like for instance, for the drunk driving offenses, which specifically allow for a 3-year period of probation on a misdemeanor, that's an exception. So for all other offenses, 1 year for misdemeanors, 2 years for felonies. Next one. The major case in California is a 1975 case, People versus Lent, and the citation is up there, 15 Cal 3rd 481. And basically what Lent states and stood for was that if you have any of these 3 things that are listed here, that is an improper condition of probation. So if the condition has no relationship to the crime of conviction and the condition relates to general non-criminal conduct and the condition forbids conduct not reasonably related to future criminality, if you have those 3 things present, then that condition which has been placed on you is an inappropriate or unconstitutional condition. And this Lent case applied to probation, but there was a very recent case that was decided by the California Supreme Court on July the 29th of this year. And in that case, which is called People versus Bryant, B-R-Y-A-N-T, the court cites to Lent, and the case deals with these community supervision, which I'll be talking about in a moment with respect to the AB 109. But it cites to Lent approvingly. In other words, it says Lent is still good case law, and it specifically mentions these 3 conditions that I mentioned here on this slide, and indicates that if those 3 are present, then the condition is no longer good. So again, it's helpful both to know that even though Lent is a 1975 case, it's been cited with approval from the California Supreme Court just this past July, and it applies to the AB 109 types of cases. The next one. Okay, so with respect to federal probation, there's still federal probation, and there's conditions of probation in the federal system. And the code section on the federal side is Title 18 of the United States Code, Section 3563A, which provides for mandatory conditions, and Title 18, United States Code, Section 3563, small b in parentheses. Most of these are pretty common sense, but again, as I was saying before, the mandatory conditions or general conditions apply to everybody. And just to give you an idea, if you look at 3563 small a number 1, which is the first one of these mandatory conditions, it is for the court shall provide as an explicit condition of a sentence of probation for a felony, a misdemeanor, or an infraction that the defendant not commit another federal, state, or local crime during the term of probation. That's a general condition of probation, obviously, on the state side. It's a general condition of probation on the federal side. It's a general condition for supervised release. It's a general condition for parole. And it makes some sense that if you are on supervision, they don't want you to commit any new crimes. And if you do, that's going to be a violation of your supervision. On the state side, many times it'll be somewhat limited in that they say you're not to commit any new felonies or misdemeanors. They usually allow for minor traffic violations, so some infractions are allowed. But it's best, of course, not to have anything, because that's a classic example of the general condition. We didn't talk about special conditions on the state side, but again, the types of conditions would be conditions for an individual who is convicted of a sex offense to have certain specific conditions which deal with having to involve yourself with therapy, having to perhaps not have certain contact with certain people. Those would be special conditions that are not seen in all circumstances with respect to probation. Same thing is true if an individual has drug or alcohol problems. There may be special conditions that deal with drugs or alcohol. So on the federal side, the discretionary conditions, again, are listed in 3563 small b in parentheses. And just again, to give you an example of those things, you have like number 4, to work conscientiously at suitable employment or pursue conscientiously a course of study or vocational training that will equip him for suitable employment. Number 6, refrain from frequenting specified kinds of places or from associating unnecessarily with specified persons. 7, refrain from excessive use of alcohol or any use of narcotic, drug, or controlled substance. So again, with respect to the general conditions on the federal side, those are listed in 3563A, and the discretionary conditions are over in 3563B. So let's look at the next slide. Now, in 1989, federal parole was replaced with something called supervised release. It was actually 1984 when the bill was passed, but the guidelines didn't go into effect until 1989. And so after that period of time, there was no more federal parole. It was replaced by federal supervised release. So those people on old federal parole used to have parole agents. Today, individuals who are on supervised release are monitored by probation officers. And if you look at Title 18, United States Code Section 3583 small d in parentheses, that's where you have the conditions of federal supervised release. And within here, again, in subsection D, there are things such as you're not to commit any federal, state, or local crime during the term of supervision. You're not to unlawfully possess a controlled substance. And then it specifically says the court order shall order as an explicit condition of supervised release for a person required to register under the Sex Offender Registration and Notification Act that the person comply with the requirements of that act. So that's specifically indicated as conditions of supervised release. There is a provision for modification, and that's at 18 U.S.C. 3583 small e in parentheses, and it indicates you can terminate after 1 year except as otherwise agreed. We'll talk about that in a moment. But what that basically means is that you can seek to modify these terms and conditions of supervised release and terminate, but you can't do it unless you've at least been on for 1 year And then there are exceptions which allow for it to go well beyond 1 year. The next one. This is the thing that Bryant case was dealing with. Because of overcrowding in the California prison system, we had a United States Supreme Court decision called Plata, which actually 2 cases, Plata and Coleman. And because the prison system was so overcrowded, first 3-judge court and then the United States Supreme Court put limitations on the population in the California prison system. And the governor was faced with having the system put in receivership and contempt proceedings. And so the governor and the legislature got AB 109 passed in 2011. And what happened was they changed where people do custody for certain types of offenses that were felony offenses and for which people used to do prison time. What it did was it created these again under Penal Code Section 1170 small h in parenthesis. It allowed these individuals to be given what would have been a prison sentence, and they're to do their time in local confinement. But what this also did was when the individual was released from confinement, they were under supervision of the probation department. So they weren't under the condition or under supervision of the parole department. And once again, these conditions would be similar to what we were discussing, where when the individual comes out, they have these various conditions, some which are formal and are general, and some which are informal or specific conditions that are placed on the individual. There are people also who were released from prison that were not placed on state parole anymore. And so this is under Penal Code Section 3451 small a. There were only a limited number of people who were released from state prison who were kept on state parole and supervision by state parole. Everybody else is now under the supervision of the probation department. So these general conditions are under Penal Code Section 3453, and this is CDC in R form, or the California Department of Corrections and Rehabilitation form 1515-CS. The next one. And these are the people who are left in the system that are still on California state parole. An example of that would be the lifers, the individuals who have life offenses, and certain types of, for instance, violent sex offenses. Those individuals are excluded from PRCS under Penal Code Section 3451 of the Penal Code, small b in parenthesis. And the general conditions for those individuals are found at 15 CCR, which is the California Code of Regulations, 15 CCR 2512. This is sometimes referred to as the administrative code in California, but those general conditions for those people released from parole or on parole are found at 15 CCR 2512. And then in addition to that, there is a separate California Department of Corrections and Rehabilitation form 1515, which include parole conditions. Now, for all of these things, again, you have the general conditions that apply to everybody, and then there are special conditions that may apply to some, but not to all. Okay, the next slide. Now we get to the concept of what to do if you have these conditions. And again, You have the possibility of moving an individual from formal to informal. So in other words, a person who is under formal supervision to be moved to informal, that's a possibility. And that's a distinct difference from termination, because when you terminate, obviously, that ends the jurisdiction, either early or when the person has done their full period of time on probation or supervised release or parole. The individual is on supervision until that ends, or if there has been a motion to modify and the individual is released early. So again, you can do that as to the complete status of being on supervision, or you can move to remove or amend certain conditions. So some of these special conditions that we've been talking about can be removed or amended. And again, that's something that can be done. One of the things that has to be looked at, though, is limitations perhaps in a plea agreement. And this is something we see sometimes in the federal plea agreements, where the individual is on supervision, on supervised release, and it specifically indicates in the plea agreement that the individual will not seek to terminate their supervised release unless they've done 2/3 of their time on supervised release. So that individual, by reason of the plea agreement, can't move to terminate it, but there is no bar in that plea agreement to modifying. So the individual may not be able to terminate, but perhaps can modify from formal to informal, from supervised to unsupervised, or supervision by the court. And the same thing is true with respect to specific conditions of supervised release. Okay, the next one. If there's going to be an attempt to try and get off of any of these types of supervision, so whether it's probation or supervised release, there needs to be some type of exhaustion of your administrative remedies. And what that means is you start with whoever is the person who's actually doing the supervision, which means that if you're on either state probation or federal supervised release or federal probation, you would go to that probation officer and discuss with them your desire to either terminate early on probation or supervised release, or that you would perhaps like to change a condition or modify a condition, or to change from formal to informal. So you have those possible things that you would like to do. And what I'm saying here is that to exhaust your administrative remedies before you seek some other remedy, it is essential that you go to that person. Now, again, it is typical for probation to say, well, we don't take a position on this, or it's up to the court. But there is something they can do, and that is they can take a position that they don't oppose it. And sometimes that you can get them at least to commit to that they will not oppose it, even though they won't say they're going to support it. So it's important to get a sense of where that individual is coming from on the state side with probation officers, and on the federal side from time to time, you'll get someone who will actually support the termination. But more times than not, they may not support it, but perhaps they won't oppose it, and that's important. And then with respect to prosecutors, so in other words, if you're going to go to court to try and either modify or terminate probation or supervised release, then it's important to talk to the prosecutor who's involved to see whether or not they will agree to a stipulation. Again, typically, the prosecutors will defer to probation. So they want to talk to the probation officer and see what their position is. And even though the probation officer will many times say, well, we're not going to take a position on this, sometimes in an informal conversation with a prosecutor, they'll agree to termination or certainly to a change in a term of condition of supervision. So again, that's part of exhausting the administrative remedies. And the last thing here is, who is the judge? Because as maybe common sense, there are certain judges that are, let's say, more compassionate or more willing to do things that would provide for early termination or for modification than others. But it also is important to sometimes remind a judge of something that they might have said at sentencing. You know, if you do well, if you do this or you do that, maybe we can provide you with some relief. And that's especially if there was a discussion at the time that the conditions were being placed on the individual where a condition was objected to or it wasn't clear, and the court said, well, this is what we're going to do, but if this doesn't work out or down the road, come back to me and I'll hear from you. So there are ways of getting the judge to modify or remedy a situation. Next slide. All right, so these are certain things that perhaps are important to look at with respect to bringing motions for early termination or modification from either to get off probation, supervised release, parole, or to get from formal to informal. And one of the things that you may have heard before, or I certainly have heard many times, is the concept, well, this person was expected to do well on probation or supervised release or parole. Why are we rewarding them for things that they were supposed to do anyway? And again, that's not something that should deter anybody from trying to get early termination or modification. So the first one, as I mentioned to you, the probation officer agrees or does not oppose. That's important. And I just spent some time talking about that. And if we have some questions, we can certainly deal with that. But the bottom line is that it's important to know where the probation officer stands and what they'll be saying or not saying with respect to the recommendation. And I didn't mention this as well, and that is that certainly if there is an agreement from the probation department and from the prosecutor, a lot of this can be done by way of stipulation without really needing a full court appearance. There can be a written stipulation and the court can sign an order without ever having to go to court. So that's something that, at least to keep in mind, that if you do have that situation where either the probation department agrees and probation, or takes no position, and the prosecutor agrees to go by way of stipulation, you can then approach the court with a stipulation, either with both the probation officer and the prosecutor and the defense attorney signing on, or perhaps the defense attorney signing it but indicating that probation and the prosecutor have no objection. The next one is job, and obviously, again, a number of people under terms and conditions of probation, supervised release, or local supervision or parole wind up having problems either finding employment because of the limitations that have been placed on them, or are having a problem keeping the job once they get it, based on the fact that the supervising entity is somehow interfering with their ability to comply with the job, either showing up at the job, wanting the individual to do other things when they're supposed to be at the job, or putting certain limitations on the ability for an individual, for instance, to use a computer, which interferes with their ability to do the job, or, for instance, to travel that's necessary for purposes of doing their job. So again, if the individual is doing everything else correct, and there is this problem in doing something that's positive, and certainly a positive thing that impacts the reintegration of the individual into the community, which, as I mentioned, is one of the important things in support of probation, but should be a common theme in any of these things, then it's something that an individual should be able to go to court on and try and get at least a modification to allow the individual to do their job, or to be able to continue with their job. The next one is completion of a program. And again, when we talk about sex offenses, it's common that the individual is going to be ordered to involve themselves in and complete therapy. And there's a couple of problems that come up with this particular condition. One is that an individual finishes their therapy, winds up having a change in probation officer or supervision, and all of a sudden the new person wants them to get back into therapy, or as a condition of probation, the person has done therapy. The probation officer has been given the latitude to decide when the person no longer needs to be in therapy, and then a new probation officer all of a sudden wants the person to be involved in therapy. So that history and their success in the program and having completed the program is important in trying to argue why either that condition is no longer necessary, or that it should be stricken, or that the individual should no longer have to comply with it. The next one is positive progress. And with respect to positive progress, as I mentioned, sometimes prosecutors and even probation officers or parole agents indicate, well, that's good, you've been doing well, but that's what you're supposed to be doing. Well, again, that's not necessarily the way everybody views this situation. And obviously, because the recidivist rate for a number of people on probation and parole tends to be high, that the idea that somebody's doing positive progress and doing specific things that can be pointed to, then that's something that should be looked at and is something that should be given credit for, and it should not be just something that is expected. So it's one of those things that can certainly, even if the probation officer or the parole agent or the prosecutor is not impressed, it's something that perhaps will impress a judge. And I'm also suggesting that perhaps you can have more than one of these things. So it could be a combination of job completion of program and positive progress. So you have a number of things that are working together here. The next thing is completion of other terms. And again, as part of the terms and conditions, there might be fines that were imposed that the individual has now paid off. So there's no fines. There could be restitution, which the individual has paid and is no longer responsible for. Volunteer work or community service that the individual has done and completed, and there's proof that that has been done. Again, and sometimes there are letters that can be written from the individual entity that the person did public service with, that or volunteer work with, which can again impress hopefully a judge for sure, but maybe even a probation officer or a prosecutor, in that the judge might have ordered 200 hours of community service and the individual wound up doing 300, or that the individual did their 200 hours with one entity and were doing some things with another entity as well. And then there are certain entities that certain judges have fondness for. So for instance, if a particular judge has been involved with the Humane Society and the volunteer work was done with the Humane Society, that might get extra points. The bottom line here is that there are ways of showing that aside from something that was expected to be done, that the person should be given credit for it and it should be taken into consideration. The next one is, again, as many people here are aware of, is the requirement, certainly on the federal side, of taking polygraph examinations, and the fact that the individual has passed polygraph examinations, in some instances has paid for the polygraph examinations. How long does this need to be done? So again, in trying to, if not terminate, certainly modify to get rid of that thing. And this again sometimes pops up where there's been a change in the probation officer, where the individual is gets a new probation officer, was no longer doing polygraph examinations or never was doing polygraph examinations, and all of a sudden is being asked to do that. And the last one here is the amount of time on supervision. I mentioned that 2/3 time that's in the plea agreement. There are some fairly lengthy periods of supervised release that are imposed, certainly for sex offenses. And so it's important to take a look at the amount of time that the individual has been on. And a lot of these judges know that this is an outlier. In other words, that this is something different than what has been required or requested for other probationers, other people on supervised release, other individuals who were on parole supervision. And so the amount of time on supervision may dictate a justification for modification from formal to informal, or termination if it's allowed. All right, I think those are the things that I wanted to talk about. So we have some time, hopefully, for some questions at this point.
Sure. If anybody has a question, feel free to raise your hand using the reactions button on your Zoom screen. I'm going through the chat to see if there's any that have been asked. Meanwhile, I have a question, Alex. Have you encountered folks saying that a particular jurisdiction, say a federal jurisdiction, has a policy of never supporting petitions for early termination? And do the judges know that? And should that be an impediment to somebody seeking early termination, or what are your thoughts on that issue?
Well, again, I mentioned that if you take a look at the statute, there may not be a bar to it, and the bar may be in a plea agreement. And for a court to take a position that we just don't grant these things, or we never grant these things, I don't know about that. Certainly in the area that I practice in, it's something that is done. But if that was done, I think that that is something that might need to be tested, because we talked about exhausting administrative remedies through the probation officer, through the prosecutor, up through the trial court, but that doesn't mean that an individual can't take a writ or can go up to the Court of Appeal if they feel that they've been treated unfairly. So there are other avenues here that one can take, and I think should take if a court takes that type of policy. I think that's inappropriate for a court to take a blank, position that they're not going to grant termination or modification in any cases. Janice?
Yeah, thank you. Alex, I have a question for you. It has to do with exhausting administrative remedies. So it seems like in many of the jurisdictions, filing a 602 form, this is for somebody on parole, can be a really lengthy process, like a year or longer. And so when would you recommend, I guess, basically pleading that the exhaustion of administrative remedies, will cause irreparable damage?
Well, again, as you're very well aware, that if you get to a point where the person's life or conditions are so impacted by this condition or circumstances that it would be inappropriate to make them exhaust their administrative remedies, one can seek relief without exhausting all their administrative remedies. But in answer to your question, technically, if we're talking about, for instance, federal parole, state parole right now, there are conditions which require them to respond in a timely manner. So when the individual, for instance, has filed with their parole agent or with the supervisor of the parole agent, they should get a response fairly quickly. And then if they don't, then at that point, they can go up to the department. So I think that there is a way to move things along. When I've run into this type of situation, I put in a phone call to the AG's office. There's usually somebody in the Attorney General's office that is designated to handle these types of issues. And when I say these types of issues that deal with the Department of Corrections and Rehabilitation, and they can sometimes light a fire or try and get things moving, even if they don't support what you're doing. So, because they recognize that there are some regulations here that need to be obeyed.
Okay, let me ask you another question, since we're here. So why do you think it is that parole likes to ignore really high-level court decisions and basically included parole conditions? So I've had two of them. It's like a repeating pattern. So it's either Buckingham, and they're basically saying you cannot have access to any social media, right? Even when the social media was not used in the offense. Or of course, the other one is the Wolfchild case, when they're saying you can't have any contact with biological children. And so I try not to get totally frustrated and upset with CDCR for being whatever they're being, blockheads, and doing this to people when so many people don't even have the sense to call us or to call a private attorney to find out about this. And it's just why do you think they do it? And is there any way we can stop them?
Well, again, this is nothing new, and obviously we have certain published cases because of that type of behavior, and a number of unpublished opinions because of that type of behavior as well. I can't answer for those departments why they continue to be serial offenders. You know, if our clients did that type of behavior, they'd be revoked. So, you know, and I'm not trying to justify it, but they need to be, if they will not accept it, if they will not respect the law, then they need to be told the law, and one needs to go to whatever entity is necessary to deal with that. Now, that's why I mentioned, for instance, short of going to court, perhaps going to the Attorney General's office sometimes will get relief.
I hadn't thought about that, so thank you for that idea.
Yeah, and many times those people are much more reasonable than the individuals who are actually doing the supervision. Every once in a while, you'll also get a supervisor that will be better than the line parole agent, and who get it and don't want to get into litigation. So it's a matter of people standing up for their rights. And I haven't said this before in this presentation, but the whole purpose of it is not being satisfied with the fact that you've been placed on probation or supervised release or parole for a certain period of time with all these conditions. At the outset, some of these conditions should be challenged and not accepted. And a good example of that is, for instance, the fourth waivers, where an individual is expected to give up their Fourth Amendment rights. That's become almost commonplace, but that's not a general condition of probation or parole. That's something that's, in my opinion, a special condition. And so it doesn't apply to everybody. And so if it doesn't apply to that individual, then it should be objected to or opposed.
Okay. Well, I think we've run out of time, Alex. Your presentation was fabulous, as always. And so thank you for
Yes.
enlightening and educating us today. And, you know, it's going to be recorded, so many more people will be listening to it after today. Thank you so much.
Thanks.
Take care.
Thank you, Alex.